Okay, and I was going to say a little bit more about my practice is also in the United States. I work in out of the Silicon Valley, dealing with a lot of software and artificial intelligence, and of course there's a couple of specific things in the U.S. I want to bring up. One of which is there's also an expedited processing in the United States that for a one-time fee you get very fast processing, and this actually works really well. And there's actually, in addition to the fact that it gets examination quicker, so typically about 2 months, there's also, at least based upon my experience, there's a difference in the examiners who are assigned to the cases that get expedited processing, and my experience with those examiners is better. And so for a one-time fee, you get expedited processing and probably with a better examiner. The result of that is, like, I had a case, multiple cases in the past 2 years where filed the application under expedited processing, get it examined within 2 months, and have it allowed immediately. Or actually getting U.S. cases allowed within 2.5, 3 months. Using expedited processing, so it's a very effective technique. Even
the Israelis would think that's good.
Yeah. Now, one of the biggest problems, which you're probably familiar with, is the issue of subject matter eligibility, sometimes referred to as 101 or sometimes referred to as Alice, because there was the Supreme Court case that kind of initiated this. And so there is a problem with anything that sort of looks like it's software, or sort of looks like it might be called an abstract idea, can get a hang up just from that, and that's is an ongoing problem. The best solution to it is to have a substantial technical detail in the specification at the outset, because if you don't have enough detail to put in later, you're out of luck. So it's really important, when you're dealing with anything related to software, put the detail in immediately before filing, because you're not going to be able to add the detail later, and that's really essential to having something that you're actually able to overcome the rejections for subject matter eligibility. And I was going to say one last thing is just in terms of all of us working together, which is that's like, well, what happens if you're working in, you're going to file an application in multiple jurisdictions? Well, you got to deal with all of the requirements of all of these. And one of the things that that I learned from practice is that sometimes my old methodology was just to file in the U.S. and then a year later just decide, yeah, maybe we'll file the PCT. That's not a great methodology because sometimes you find out later that, well, like maybe you didn't have enough detail to survive in Europe. And it's like, well, you can't add any detail later. So the key thing is to get some idea of where you're likely to file and make sure that you're upfront, including all the detail that might be necessary for whatever jurisdictions might be included. It doesn't hurt if you don't file in these jurisdictions, just like, but if you are going to file there, be ready for it.